We're going to give this just another minute or two as people seem to be still signing on, and then we'll get started. If we could have all the presenters turn their mics and cameras on, please. All right, it's just about 12:30, so we're going to get started. I'd like to thank you all for joining us and welcome to week 3 of the Bressler, Amory, and Ross COVID-19 webinar series. And special thanks for those of you who can't see the participant list. Apparently we have most recent presidential candidate who stepped out, Bernie Sanders, who has joined us today. So quite creative of somebody signing in this afternoon. For those of you who don't know me, my name is Evan Yablonsky. I'm a principal in our Florham Park office, and I have the distinct pleasure this afternoon of getting to moderate today's panel. You all don't need me to tell you that the world continues to turn upside down from the global pandemic. And first and foremost, we obviously hope for everyone that they stay safe and healthy during this tumultuous time. But we also all know that despite all the social distancing and quarantining, that all of our businesses are doing everything they can to continue and to continue in the best way possible. And how we're all transitioning into this virtual world is what today's webinar is going to be about. If you're anything like me, a month ago, maybe you'd used Zoom once or twice. Maybe you've heard of Fuse or Microsoft Teams, but it certainly wasn't an everyday part of the way it is now. And this has had a huge impact on all of our businesses. And thankfully, we've got a few principals from Bressler, Amory, and Ross that I'd like to introduce today that are going to share their expertise with you and explain how best they found to handle this changing world. Andrew Egan, principal in our Trust and Estates Department, is going to be speaking with us about how to handle things like wills and trusts and power of attorney when everyone's stuck at home. Lauren Fenton Valdivia, the principal in our Business and Commercial Litigation Department, who also practices in the employment arena, is here. Lauren's going to be discussing the ins and outs of internal investigations and how you need to adapt those internal investigations to fit today's situation. Nicholas Camiotti is a principal in the Financial Institutions, Litigation and Arbitration Department, and he's the head of the firm's cannabis practice. And Nick's going to be discussing how alternative dispute resolution procedures have changed, as well as, quite frankly, how to maintain an office productivity and an office culture when no one can actually go to the office. And then last, but certainly not least, is Diana Manning. She's a certified trial attorney. She's a co-chair of our firm's Business and Commercial Litigation Department. And Diana is going to be discussing for us today the rules and strategy decisions that you need to be thinking about as our courts move towards these virtual appearances, oral arguments, depositions. And so I'd like to, if we can, I'd like to start with Diana. And Diana, a few weeks ago, we were all talking about, how are we going to have a deposition and can they go forward? Now we know in the last 2 weeks that's happening. Everyone's taking depositions, everyone's moving forward in that manner. And now we're turning towards courts actually wanting to hold conferences. They want oral argument, they want appellate arguments via Zoom, Skype, Fuse, whatever the case may be. So I guess my first question is, are there rules of professional conduct? Are there things we need to be aware of in light of this new change?
Yes, Evan, thank you. It was nice to have a reason to get dressed up today as I'm working from my office/kitchen. Yeah, tech is moving so fast right now, and things are moving so fast that we've even outpaced the PowerPoint. When we talked about doing this presentation, we talked about, really, we were focusing on depositions and all the things you need to consider. But you know what? That, whether or not they can be done, that ship has sailed. We know they can. We know they can be done remotely. They know swearing in can be done remotely. And now we've leapfrogged to the point where everybody wants to move forward to more things. They want to move forward to, can we do a video mediation? Can we do a hearing? What about client meetings? So what does that mean for us? Well, really, I'm going to talk about two major issues. And the first is, are we required to be technologically competent? And if so, what does that mean? And second, just because you can do it, does that mean you should do it? So it's interesting. A couple weeks ago, the days are all kind of blurring together here, but the Law Journal did an op-ed piece, the editorial board, and they said, hey, New Jersey needs to revisit the issue of whether or not our RPC should be amended to include specifically technological competence. And that's interesting because a couple years ago, California amended their RPCs and said you have to be technologically competent, although they didn't define that. And I had an opportunity to talk to Justice Ann Patterson, who had spearheaded a committee that reviewed that. And she said, you know, we didn't think we needed to amend the RPCs because our RPCs say you have to be competent. And if that involves technology or whatever it is, you still have to be competent. And we didn't want to get specific because we don't know where tech is going to go, and we don't want to start identifying things and have that be passé. And in fact, she was right. I mean, for a long time, I was on a district ethics committee in New Jersey. In the last 2 years, I was the chair. And you're not even allowed to use email in connection with ethics committees because the Supreme Court doesn't think email is secure. You had to use faxes, which was kind of interesting because a lot of people don't even have fax machines anymore. And if they do, your fax is sent to your desktop through your email. So it created all sorts of conundrums. So she had a point. But this issue is clearly going to come to the forefront for us all. What does it mean to be technologically competent? Now, you know, I'm a principal at Bressler, Amory, and Ross. When I'm at the office, I am technologically competent. We have a great IT team. They can set me up in a conference room with a big screen, and I can do a remote deposition. If the witness is in another place, and typically you'd have your reporter with the witness swearing them in. And now the world has changed. I'm coming to you from my office/kitchen where my neighbors are apparently cutting down trees. So thank God I had my old school earbuds because otherwise the noise would be horrific. I'm also on an iPad because I had a New Year's resolution that I was going to buy a new laptop. And like most New Year's resolutions, I haven't gotten around to it yet. It's embarrassing, but mine's so old that it couldn't possibly do video for something like this. I can get into our system, but I can't do a webinar from my laptop. So what does it mean to be technologically competent? What type of equipment do you have to have? What type of equipment do you have to provide witnesses if you want to do a remote deposition? Who's got to provide the equipment? If you're taking the deposition, do you have to provide that equipment? So there's a lot of things, right, for all of us to consider, because I don't know about the other presenters, but for me, all of a sudden, appearances, live appearances, this means I'm the lighting director. I'm trying to maneuver the height. I want to have the best view so I can be most effective. What technological competence means is going to be, I think, a moving target. So where do we go from here? Well, now there are a lot of things we really have to think about. So last week I got a text from one of my colleagues in Morris County. He said, "Oh my God, have you been on the court website? They're live streaming hearings. It's crazy. You should see what everybody's background looks like, even the judges. You should see what they're streaming." So I tune in. NewJersey.gov. They were live streaming a lot of arguments. And the one that I clicked on happened to be a family hearing with two pro se individuals. And on the screen, I had their full name. And one of the issues that came up was mental health care for the couple's daughter. This was not the type of thing that I thought should be streamed live over the internet. And apparently I'm not the only one who's thought that, especially in family court cases now. People have been recording the streamings and then posting them on Facebook or other social media. So we're going to start with hearings here. If you have a hearing and it's being videotaped as opposed to audio, you have to consider whether or not there's confidential information. If this argument is going to involve confidential information, then you have to bring that to the attention of the judge. In New Jersey, judges are supposed to address that, and if it's appropriate, either not stream the hearing or handle the hearing in such a way that the confidential information will be protected. But you can see how this could come up in any number of cases, because we know how arguments are going to go. You may start with one issue and your adversary may bring up a past issue that maybe involves confidential information of a client. And normally you'd be in court and you just answer it, right? Because these days, who else is in the courtroom? Usually you're there by yourself if you're having an oral argument. Now it might be getting streamed over the internet. So if you're doing a video hearing, you have to be mindful of the things that you might not want to say while your hearing is being live streamed. And I do think we're going to have a lot more disputes and issues coming up as now more hearings are being done via video. I mean, in New York just announced that they're going to move to handling non-essential civil matters remotely. So a lot of jurisdictions are now moving to using tech. So all of us are going to have to be mindful of what is the pitfall of having an argument over a medium that can be recorded, and certainly in hearings and things like that. So we have to think about what kind of information are we talking about? Is it confidential? And if so, how can we address that with the court? The next issue is mediation. So although Zoom is a new technology for many of us, I didn't know anything about Zoom until I was asked to give a webinar a couple weeks ago. Zoom has actually been around since 2013. This is not a new technology. So I think it's fair to say that if everybody thought that remote mediations were going to be effective, they would have taken off before now. I mean, now it's all we could have for those of us who are in a lockdown situation. But I think that most people think that remote mediations aren't that effective. I mean, there's a lot of things that you have to consider before you agree to go forward with one. In mediation, things like face-to-face discussions, looking at people's body language, being able to have that one-on-one conversation, and perhaps the mediator's ability to keep all the parties from walking away. I mean, here, if you don't like or think our webinar is going well, all you have to do is click a button and you've disconnected, and that's true for a mediation as well. I think it's harder to keep people engaged. It's harder to keep people from being distracted. Everybody's getting notifications on all of their tech. Hey, you got emails, you got texts, you got this, you got that. It's interesting. Harvard Law School did a study negotiators who negotiate in person typically get a better deal. So what does that mean for all of us? It means that clients and lawyers have to consider whether or not a remote mediation makes sense. And maybe it makes sense as part of a two-pronged mediation. Maybe you're going to start remote and finish when people can be available live again. Maybe when things get back to normal, some people will be there in person and other people will be there remotely. Well, that's going to depend on whether the clients are comfortable with remote mediation. And I think there's going to be a lot of discussion and potential claims by clients who say, I didn't really understand, not out of mediation, but just in general with tech, I didn't understand the pros and cons. I think there'll need to be a lot more discussions between lawyers and their clients about what are the pros and cons. And especially with sophisticated clients, is this a case where using this type of tech for a mediation, which is typically voluntary, is that something that makes sense? So there's not going to be a one-size-fits-all answer with each case, especially with mediation. You're going to have to do a case-by-case analysis. It's going to involve some thought and some discussion about that. Some cases it might work, and other cases it might not. So we also have to be mindful of the pitfalls of tech. We all have really short attention spans now, mostly because of tech. So there has to be some ground rules if you are going to go forward about how many things people should be doing at one time, for sure. The last thing I really want to talk about is depositions, and not so much because I think that we know, especially in New Jersey, there was an omnibus order on March 29th that says, yes, deps can be handled remotely if all parties agree. And we're certainly recommending that if you're going to go forward remotely in New Jersey, that agreement between the parties sets out the ground rules, and that's in writing. But I will say this, certainly in New Jersey, remote depositions are off to a slow start. My husband's a lawyer. He runs a large staff counsel operation for Liberty Mutual. In a typical week, his office will take about 75 to 80 depositions, his attorneys. This week, they're trending towards 10 being done remotely. There's a reluctance. Some lawyers are taking the position that they won't do remote deps at all, which I don't think will be sustainable. I've been on a lot of calls on different committees and panels with judges who say the longer this goes on, the less likely you're going to be able to just say, I won't do deps remotely, and we're just going to have to wait until this all opens up, because there's going to be a lot of issues. We don't know what opening up is going to mean, right? If you have a witness who's of advanced age or has a compromised immune system or something like that, they may refuse to appear in person. You may have attorneys who refuse to appear in person for those reasons. So there's going to be a lot of considerations if there are motions to compel depositions about whether or not the dep is appropriate to be done in person, appropriate to be done remotely. And some jurisdictions in the country are now at the point where they're issuing omnibus orders that say, we're ordering everyone, if it's noticed, to do the dep remotely unless there's a compelling reason not to. One court in Texas did that, and they said specifically in the order, a compelling reason not to it's not enough to say, I don't want to do it remotely. So I think that we're all going to have to really consider whether or not doing a dep remotely makes sense. It may be easy to do if it's a shorter deposition or there are less parties. It might be more difficult to do in a complex case where there's multiple parties and multiple principals who want to attend. It may depend on your exhibits, because you have to think about what are you going to do with the exhibits. Oftentimes, we all want to wait to give the witness the exhibit in the moment? How do you do that? Are you going to show it electronically? Are you capable of doing that? There's been a suggestion that you could send all the exhibits to the witness ahead of time, have them all, each individual exhibit sealed in an envelope, and then you would watch them open the exhibit. I mean, for me, if I'm taking a video deposition, kind of the way that we're all presenting to you wouldn't be acceptable. I can't see everybody's hands. There's already been a case that came out of New York that got some publicity where there was a remote deposition going on. It was on something like Zoom, and the lawyer and the witness were on private chat discussing the answers. So there's a lot of things to consider. What type of relationships do you have with your adversary? Is there some trust there? Do you trust that they won't do something that is unethical? It makes instructions really important for a remote deposition because you want to say yourself to the witness, you shouldn't be having, in New Jersey, you're not allowed to have conversations with the witness once the dep starts. You want to say to the witness, you're not allowed to talk to your lawyer, and that includes texting, and that includes emailing, and that includes the private chat feature on Zoom or Skype. So there's a lot that you have to think about. You want to be mindful that you don't know who else is present where the dep is happening. Where we're all in lockdown now, you might be deposing a witness whose spouse is in the room. And how many times have you been in a dep where the witness says, oh, if I could only ask my wife, I could tell you the answer. And you want to make sure that they know that they're not allowed to ask their wife. You're just trying to find out what they know. And the ground rules and the rules of the game really need to be explained up front to everyone. So there's a lot of things to think about when you agree to do these types of things. And that's going to be something that I think is going to be a moving target as all of the technology evolves and how we're doing it all together. The cardinal rule for all of these proceedings, and in particular depositions, is if you're not allowed to do it live, you're certainly not allowed to do it over tech. But I think that we all know, right? Email. How many times have we all been told not to put something unsavory in an email or in a text? And how many times do you handle a case where you say, what were they thinking when they put this into email? Electronic and technology and iPads, they seem real casual. They seem like conversation. They seem like they're just going to go off into thin air. And we know that that's not true. Now, if you have any kind of virtual meeting, the person on the other side or the people on the other side might be recording it. And then they're going to have a recording that could go out into the world. So these are things that everyone has to really consider. And I'm not going to go too far into this, but a major consideration on all of these things is certainly security. But I know that Lauren is going to talk about that. But there's a lot of information out there now, including information from the FBI, about how to make remote meetings and conversations secure, because certainly you don't want to be in a position where something that you didn't expect to be disseminated was disseminated, or you don't want to be in a position where you're having an attorney-client privilege conversation and the privilege is broken. Again, if you're having a conversation with someone who's in their house and they have other people standing around or sitting around, one could argue that there was a waiver of the privilege. So I think that everything that everybody's doing now to move forward in the practice of law is also going to lead to a lot of unique arguments, and that we're all going to have to deal with. So, we're entering a whole new world here, and we're all going to have to try to keep up. I know for me, I will tell you that I have a pair of earbuds on their way whenever they get here, possibly mid-May, according to Amazon. And as soon as we're back in the office, I'll be talking to IT about what kind of computer I need to get. But those are, all the kinds of things that we're all going to have to keep thinking about.
Thanks, Diana. It certainly sounds like a lot of complex issues that we need to be addressing and really thinking about before we enter into depositions, oral arguments, mediations, whatever the case may be. And I know there's going to be a lot of similar issues that you need to worry about when we're talking about remote workplace investigations. Lauren, can you kind of walk us through how you go through a typical workplace investigation, what the goals are, and how that's changing in light of this pandemic and this work from home environment that we're all facing?
Of course. So obviously, Diana talked a little bit about the litigation aspect. When you're talking about workplace investigations, you're typically talking about pre-litigation. So here, really, we're talking about when you're an employer and you're facing an employee complaint that rises to the level that you need to complete an investigation, i.e. a complaint of discrimination or a complaint of harassment. How do we, as the employer, actually conduct that investigation in light of this current pandemic and the remote world we live in? Diana started the trend about her office, but I will tell you my office is currently my guest room, although I have strategically placed myself in front of a closet so it looks super professional, right? But how do we conduct these investigations in light of what's going on in the world and make sure that we're still accomplishing the goals of an investigation? So really, when it comes down to it, regardless of if you're working virtually or in sort of face-to-face capacity, there are three sort of overarching general goals of any investigation, any workplace investigation. And those three goals are essentially that you want your investigation to be timely, you want it to be thorough, and you want it to be impartial. And here, those first two elements are really the two elements that I'm focused on in terms of what could be different in a virtual investigation. Are we permitting the virtual nature of an investigation to affect the timeliness or the thoroughness of the investigation? And obviously, the easy answer is that the virtual nature of an investigation should really have virtually no impact on the timeliness or the thoroughness of the investigation. So let's start by looking at sort of your investigation plan. And I guess before we even get there, let's talk, I swear that one's not mine. But before we even get there, I guess let's talk a little bit about who is the right person to conduct the investigation. So really, you have two choices. Your choices are that you can have inside personnel conduct that investigation, or you can have outside counsel conduct that investigation. And there are pros and cons to each. And so just briefly, I think the considerations here are how experienced are your inside personnel to conduct these investigations? And to the extent that they lack perhaps some of the experience to conduct this investigation, is it going to be further belabored by the fact that they are now working in a remote world and they're having to do and move all these parts to an investigation while also working remotely? The other thing to consider is the appearance of partiality, right? So the nature of having outside counsel come in to assist with an investigation is that you are almost covering the investigation with impartiality. Especially if you have a smaller organization and you have inside personnel conducting the investigation, there always gives rise to the inference of partiality, especially if there's, a collegial nature, if the HR person or the human resources person knows everybody in a smaller organization. So partiality and the appearance of impartiality is certainly one thing to consider. And the last thing to consider really in terms of the pros and cons of inside counsel or inside personnel versus outside personnel is really just the timing issue. An investigation, you want it to be completed as timely and thoroughly as possible, and you want to get to that conclusion. Well, if your inside personnel is really just exclusively focused on an investigation, they're surely not looking at other potential time issues that are coming up in terms of employees and human resources issues. So once you decide who's conducting the investigation, what does the investigation look like, and how is that affected by us working remotely or virtually right now? So really, when you decide who's doing that investigation, the next step is really to come up with an investigation plan. And that plan really considers who are the witnesses or the people that you're going to be interviewing, specifically what order you might want to interview them in. There might be specific people that you're concerned about confidentiality and whether or not they're going to sort of go back and have discussions internally that you want to kind of avoid. So who are you investigating? Who are you interviewing? Excuse me. How do you conduct those investigations in a smart manner in terms of the order that you're investigating people? Also, what documents or data do you need? And that's really one thing that could be affected by the current pandemic. Certainly, a lot of organizations right now are moving to having everything on a computer. You have access to different policies and procedures on an intranet. But when I'm reviewing documents in these types of investigations, sometimes I'm finding that I don't have access to certain information that I normally would have access to because nobody's in the office to get it. So really the investigation plan now is, what witnesses do I want to interview? What documents do I want? And to the extent that I have a document that I want that I don't have access to because an office is closed or there's a stay-at-home order, how am I still completing that thorough investigation despite not having access to that information? And then I guess in terms of the thoroughness, when we're talking about people working remotely, how do we access people, right? Because part of this is now people are being very strategic about their schedules. I know I certainly have been very strategic about my schedule in terms of my children, but people are being strategic about the weird nuance of having to perhaps homeschool, and you have employees who perhaps are shifting their hours a little bit. So again, how are we getting through this investigation in a thorough and timely way, while also respecting that certain people's abilities to be available and present the way that we would be able to just call them into an office when we're all physically present is very different in the current world.
Thanks.
Lastly, I just wanted to speak briefly on the confidentiality issue, and I'm going to try and keep it brief because I know we're running tight for time, and I definitely want to give Andy and Nick an opportunity to speak. But the confidentiality issue is one that I guess I don't think we're going to have the best answers to right away. And I'm sorry, before we get to confidentiality, I would stress that I think the use of video conference is paramount rather than phone conferencing. When you're interviewing witnesses, assessing the demeanor and the credibility of witnesses really does turn on being able to view them face to face, even if we're not physically face to face. We know from certain jury instructions now, specifically in New Jersey, that the judge instructs the jury that you can assess the credibility of witnesses based on their demeanor, among other things. So we certainly know that one of the best ways to assess demeanor of a witness is through seeing them face to face or via computer screen to computer screen as best we can. Lastly, I just wanted to briefly discuss the idea of confidentiality, which Diana touched on, but I don't think we have the best answers yet. I feel like every day I'm reading a new article on what Zoom has in terms of capability or what other video conference systems have in terms of capability. I certainly tend to use Zoom, and I find it to be very effective. And one of the more effective ways to use Zoom is to be able to generate meeting invites with passcodes. So that way you're making sure you know exactly who's on the meeting. But when you're conducting an investigation, like Diana hinted, how do you know who's in the room? The sensitive nature of a workplace investigation is that you're trying to keep things as confidential as possible. You don't know who's behind the computer screen, who's sitting off to the side. So all you can do is best encourage people to keep things confidential, and then also ensure that you know how the video conference system that you're using, what the capabilities are. As the moderator or as the generator of the invite, are you able to see if somebody's recording that interview or recording that that investigation, that part of the investigation? So every day we're seeing new articles. I think a new Forbes one came out this morning on the fact that certain Zoom videos were all being saved to a certain drive, and that people were able to access it online. Every day there's something new coming out. Obviously, the nature of a workplace investigation is that we're trying to keep things as confidential as possible. So there really just needs to be a good understanding of the capability of the equipment that you're using and the capabilities that you have as a moderator to essentially lock things down. So with that being said, I guess I'll turn it over to Andy, who I know is going to speak on some really timely issues on estates and trusts.
And before we turn it over to Andy, just because I know there's a lot of people in the virtual room that want to make sure they're getting their CLE credits. So the first word for today's CLE is doctor, DOCTOR, and I'll put that, I think Nick is putting that up in the notes for us as we speak so everyone can see it. You can probably start to guess what the next word is, but we'll save it until after our last presenter. And with that, Andy, I can't help but imagine people are incredibly concerned in today's day and age about their health, and as morbid as it may sound, making sure that their loved ones are taken care of. Should happen to them, especially in this heightened environment. Talk a little bit for us about how you're handling those issues from a trust and estates capacity, power of attorney, things of that nature.
Sure. And you're right. There's an old joke in trust and estate circles that there are no T&E emergencies until the client's going on vacation the next day. Then you got to sign a will that day, and it's a fire drill. But in the current environment, we are seeing a lot of people, perhaps for the first time, confronting those uncomfortable realities of mortality, of trips to hospitals, of the inability to make your own decisions. And this crisis is forcing a lot of people to reconsider what their own estate planning documents look like, whether they have a will at all, whether they have a healthcare proxy, whether they have financial powers of attorney. And as we are getting a lot of calls and a lot of emails from people looking to address these issues and to consider their own estate plans and update their own estate plans, the reality is that we're having an issue and we're working around it with the fact of physical presence isn't possible these days. The holy trinity of estate planning documents is a will, a financial power of attorney, and a medical power of attorney. And what those documents have in common is that they all require that the person sign them in the presence of witnesses. Some require notaries, some don't. And then there are further complications that, for example, in your healthcare proxy, the person you name as your agent can't be the witness. So you have a situation where people are trapped in their houses. In general, they want to name their spouse as their healthcare proxy in case they get sick, in case they have to go to the hospital. They need somebody to make medical decisions for them. But in both New York and New Jersey, I can't speak for Florida, but I'm assuming it's similar. The person you name as your medical decision maker can't be the witness. So where are you going to find a witness? I mean, it's possible to do it. We're seeing some law firms are doing drive-by signings where people are signing in their cars. They're doing it in public spaces outside, essentially a picnic table at the office, where one person approaches a table at a time. Everyone brings their own pens. Everybody's masked up and gloved up. And there are some ways to work it that way. But in general, I'll start with the will. You need to have a valid will in everywhere we have an office, which is New York, New Jersey, and Florida currently. You need two witnesses. The testator has to sign a document in the presence, physical presence of two witnesses. So e-signing, meaning virtual witnessing, virtual, you don't need a notary for a will, but you do need it for a self-proving affidavit, which helps the probate practice go a lot smoother. And up until, I'll circle back to this, but up until yesterday, e-signing was not an option in most states. Nevada is an exception, and Florida, as of July 1, will allow it. I'm not sure they're going to move that up for the emergency. They might. There are some other states exploring virtual execution of wills, but in general, New Jersey doesn't have it. New York, by an executive order Governor Cuomo put out yesterday on an emergency basis, now does allow it. I'm going to circle back to what the requirements are for that. So we have a real issue in terms of wills. You may not be able to find two people to sign in front of. There are some workarounds. In New Jersey, for example, New Jersey allows holographic wills. What a holographic will means is that all of the material portions of the will are in the testator's own handwriting and are signed by the testator. So you can do that without a witness. But I caution you not to go out to Staples and buy a form will, because then you're only filling in the blanks. And then the only thing the court will look at is the blanks, which don't make any sense out of context, the printed form that you have. So you have to write the entire thing in your handwriting. That's one workaround. The other in New Jersey is what we call Section 3B33, which allows You can prove a writing is intended as a will if you can meet the clear and convincing evidence standard, which is a high bar, and does require you to go to court after the person's death. You have to show that they intended this document, they reviewed it, and they intended it to be their will. You can imagine some workarounds in a crisis where you would think that would pass muster, but we're in uncharted waters where, I mean, for example, we could email someone a will in PDF. They could take a look at it, print it, sign it, send a picture back and say, yeah, I intend this to be my will, and that's it. I wouldn't include any other language about we're going to come in later and sign it and make it formal, because that raises some questions. I heard another practitioner is using the holographic will combined with a revocable trust. So the holographic will, as I mentioned, you can do on your own without a witness in your own handwriting. So you can have everything pour into a revocable trust. We can send the trust by email, and there is no witnessing requirement or notarization requirement for a revocable trust in New Jersey. So that is another workaround. So there are some people are getting creative in a situation where we didn't expect to find these kinds of issues, but very, very quickly and in a very real way, people are concerned about these issues, and we're trying to figure out the workarounds so we can keep people executing their documents. I wanted to talk about New York has previously, as of March 19th, allowed virtual notarization by an executive order. That executive order was only for 30 days. I think he just extended it yesterday into May 7th. And the requirements are that you have to have a valid ID during the video conference. You have to have a direct interaction between the notary and the signer, meaning it can't be a pre-recorded video. It has to be an interactive setting like Zoom or Fuse. The signer must be physically located in New York, and as well as the notary. And you must send a legible copy of a signed document to the notary the same day it was signed by fax or by electronic means. There are also requirements that the notary make a video recording of the session and keep it. I'm unclear on how long they have to keep it, but it's a period of years, probably 7 years, but I have to follow up on that. And by executive order yesterday, Governor Cuomo amended temporarily the estate powers and trust laws, the public health laws, the real property laws, the general obligation laws, for the purpose of allowing virtual witnessing. Similar to the virtual notarization program, the person requesting that their signature be witnessed, if the witness doesn't personally know that person, must present a valid photo ID during the video conference, not merely transmit it prior or after. The video conference must allow for direct interaction between the person and the witness, so no pre-recorded videos of the person signing. The witness must receive a legible copy of the signature page via fax or email or electronic means on the same date that the pages are signed by the person. And then the witness may sign the transmitted copy and transmit it back the same way to the person. So we're trying to get creative on how we can work around some of these issues. And so far we seem to be doing okay on these issues. As far as some of the other documents, some of which do require notaries, that's a little trickier. New Jersey does not have a virtual notarization statute or an emergency provision like New York now does. So, for example, healthcare proxy, you can sign with a notary or two witnesses in New Jersey. You have a choice. And again, one of those witnesses can't be the agent that you're naming. So you have to actually have, could have 3 people nearby, adults, who can witness this. Or you can find a notary. UPS stores and banks don't usually like to sign estate planning documents as notaries, but perhaps the UPS store or the FedEx store may have a notary on staff. New York requires 2 witnesses. It does not require a notary for your medical power of attorney. In New Jersey, it does require a notary. So for now, that is actually the hardest document for us to work around, is the financial power of attorney in New Jersey. We don't seem to have a way around that at the moment. New York's is a standardized form and does require a notary. And it also requires the agent's signature. But it appears that New York has now addressed this with the emergency order for virtual notarization. There are 2 proposed bills kicking around in Trenton. on some of the virtual notarization issues. One is a more temporary basis one, and the other one is a more long-term. But so far, they have not been enacted. They are not the law, and there is no executive order that accomplishes those goals. I just wanted to touch really briefly on some of the estate planning substantive tactics that are changing right now. Obviously, the economy has changed a lot in the last month. A lot of people have lost significant portions of their net worth, and a lot of people are worried about how they're paying the bills. But there is a segment of society that, even though they may be significantly poorer on a net worth basis than they were a month ago, they are still trying to plan ahead and see this as an opportunity to do some generational wealth planning. And in particular, people are using the market volatility and the extremely low interest rates to do gifting, in particular to GRATs, which is a grantor retained annuity trust. And the advantage of all this is that you're moving assets at values that are hopefully going to spring back in a little bit, but for now they are temporarily depressed. So you get the advantage of locking in the value when you make the transfer. You know, the market's come back off the bottom so far, but there might be another leg down. There might be some more volatility. So there are, you know, for those people who are not worried about making their rent payments and you know, are sitting on $11 million or whatever the federal exemption might be for their situation, there are some opportunities substantively to do some planning in this environment.
Thanks, Andy. Unfortunately, I'm not sitting on $11 million, but as soon as I am, you're my first call.
Not yet, Evan, not yet. Right.
Not yet. Before we turn it over to Nick Camiotti, for those of you who are looking for CLE credit, our second CLE code today is Fauci, F-A-U-C-I. So for those paying attention, it is Dr. Fauci, who we all have come to know through his daily briefings. With that being said, I'm going to turn it over to Nick. Nick, we've talked a lot about internal investigations and litigation and the courts, but as we all know, for those of us who litigate, so many of our matters are handled through alternative dispute resolution. How is that being addressed in light of the pandemic?
Well, thanks, Evan. First, I just I didn't realize that there was a wills aisle in Staples. So, Andy, thanks. I learned something. I hope other people took away a little bit more than that, but that's all I kept going.
Yeah, we try to keep that quiet. We don't want that getting out.
I didn't realize that. I thought like construction paper, maybe a hole puncher, something like that, but didn't realize that I could get my T&E plan done at the local Staples. So
I'm not saying they're any good, but they're there.
So anyway, thanks. What we do a lot in the financial institutions practice is a lot of arbitration. So we've been dealing with some of these video conference issues on a smaller scale for a number of years now. As it became more available, when I first started, occasionally a small witness would appear via telephone, and then once video conference got better, the scope of the amount of testimony that you could obtain in an arbitration via video conference expanded. Obviously, you want your primary witnesses, the main witnesses, to be there. However, if there is somebody in operations or somebody who handled a specific discrete issue and that was out of the office in Pensacola, Florida, and the arbitration was happening up in New York, maybe it didn't make sense to fly somebody up and have them sit in a room for what was a half hour to an hour worth of testimony. And generally the panels were understanding of that, and usually it was a client request and a client accommodation that the panels would agree to. So not surprisingly, once the COVID-19 crisis began, most of the major alternative dispute resolution providers issued guidance saying that video conference is available. Hey, file everything via our portal. We like to get paid as a third-party service provider. Please continue to sue each other and proceed with your litigations. So you see jams issued guidance on that, saying they have available systems that are available. They use, as we've talked about a lot, and a lot of this stuff's been covered, and I know we're getting close to the witching hour, so I'll expedite things. But a lot of the third parties, alternative dispute resolutions providers use Zoom for their systems. One thing I found interesting is JAMS has a proprietary mediation platform called NDispute. I've never used it, so I can't attest to whether or not it's good, but they talk it up quite a bit on their website about it being, you know, cutting edge when it comes to mediation technology. So I tend to agree with Diana. I find mediations to be more effective when you have everybody in a room, because half the time some of the leverage you have is, oh, all right, that's it, I'm going to leave. If we don't get some traction here, or if we don't get some movement here, we're going to leave. If everybody's on the phone, I don't find that to be nearly as effective. AAA has their own guidance. They want people to proceed via video conference if possible. But critically, with all of these forums, arbitration is something that is a matter of contract. So every forum that I've seen so far is requiring both parties to consent to proceed via video. FINRA, which we participate in a lot with our financial institutions practice, says that issued guidance saying that if the parties both agree, they can proceed with the hearing via video conference, excuse me. But they do have a carve out allowing for motion to be filed on behalf of one of the litigants who wishes to proceed over the objections of another party. I find that to be interesting, and I think that there's going to be some motion practice in that area, because I find I think some of the claimants are going to take the approach that generally in our financial institution retail brokerage cases, the claimants or the plaintiffs are elderly, and usually the claimant's attorneys are pushing for expedited hearings and will accuse the respondents or defendants of dragging their feet, stalling, things like that. And I think that you'll see some litigation tactics arise from this, where you'll start to see some of the claimants pushing for it, even if they don't really want it, just to accuse the other side, the defendant, of wanting to delay or dig in their heels and not really want to get to the merits of the case. I think that you'll start to see that as a little bit of a tactic, because I do think that ultimately panels are going to be very hesitant to grant, you know, a video conference over the objection of a party, mainly because I don't think that we're dealing with the most technologically savvy group of individuals. Generally, it's 3 retired or, you know, close to retired attorneys or other professionals. You're not really dealing with a bunch of people who are sitting around making TikTok videos in their free time. So I think that, you know, that's going to be difficult for them. As a practical matter, using video in part for a part of a hearing, I find to be effective and fine. However, I don't know how it would translate for an entire hearing where you have the 3, well, generally it's 3 arbitrators that we're in front of, but you have 3 arbitrators sitting in 3 different rooms. I don't know how effective that can be. It'd be more difficult to read what's going on in the room versus where you have one person appearing, but everybody else is in a room together. I think that allows for some problems. Obviously, we talked about the confidentiality issues. Arbitration is supposed to be confidential. It's supposed to be expedient, and it's supposed to be cost effective. So via video conference will accomplish 2 of those 3 goals, but the third goal of confidentiality is something that needs to be worked out. Obviously, secure links, things like that. You would think that there could be workarounds for that would allow to maintain the confidentiality here in arbitration, because unlike the court system, as Diana discussed, these things aren't open to the public. So some of the issues that you have in court where you really got to put something under seal to keep people from viewing it, you really shouldn't have those issues. That said, you could have some people taping it and then, run into issues of trying to enforce and put the cat back in the bag. If, let's say you're representing a financial advisor and his testimony is recorded, and the next thing you know, it's all over Twitter or Facebook or whatever, by an aggrieved claimant, look at this guy lying, this, that, and the other thing. I can see a lot of problems coming from that. I know we only have a couple minutes left, so
quick question before you move on. Do you think this is going to have an impact on people's likelihood to settle? It can encourage settlement because of all these issues that you're discussing?
I think that it will go both ways. I think that some people will use this as an opportunity to, I think taking away the technological piece, I think talking about what we're dealing with, I think you're going to see some position like, oh my God, this has had such a bad impact on my client. You think we're sitting on $80 billion. We've got 11. So if you want 5 of the last $11, you should probably strike now before my client goes to bankruptcy. I think you'll see some of those type of negotiations like, hey, we're running out. We don't know how long we're going to be here. This is a really struggle. This is really killing us. So I do think there will be some of those types of settlements. And then I think there will be some of the larger, bigger entities may look at this as an opportunity to work a better deal and try to wear people down, knowing that people are, hurting now. And if they may not be looking to get 100 cents on a dollar, if they could get, 50 cents and have it in their pocket, that may be something that would getting a resolution on more expeditiously will be something that I think some litigants will want to go. I think it's going to go both ways. I think it depends, and it depends how how large of a number it is. But because the larger the number, the more entrenched people seem to be.
That makes sense. And then stepping aside from the ADR and kind of this virtual world issues in litigation, how are you, or what's your advice for handling an office, keeping up morale, making sure everyone's communicating, things of that nature?
Yeah, so when we obviously have never dealt with this. We've got almost 300 employees at Bressler, and how you keep people connected is a major issue. Thankfully, we rolled out a new phone system, this Fuse platform that we are using now, a short time ago. And it allows us to communicate via video conference, excuse me. It allows us to collaborate more. When we're working we're pushing people to collaborate, work on projects together more frequently. We're having more team meetings, things like that. It's more scheduling, more communication, those types of things where you're not going to just bump into somebody and be like, hey man, let's talk about this. Or, hey, I've been meaning to catch up with you. Let's chat and pop into a conference room. Those things, the organic communications that happen when you're in an office is obviously less sparse when you're sitting in your home office, bedroom, kitchen, wherever you are. So you really have to take the initiative. I've advised people who work for me and with me, and that I work for, communicate up, communicate down, make sure that people are discussing things left and right. And, when all else fails, try for a virtual happy hour, maybe get a few people, have some cocktails and bring together that source of togetherness. But what we're trying is what we're doing with this initiative to stay in front of people. We have some clients with contacts, and we have other attorneys on the call that we're just trying to let everybody, give everybody an opportunity to communicate and collaborate. So that's what we're trying to do with this weekly webinar, and that's what we're trying to do internally and externally, and hopefully people are appreciating the efforts.
Well, thanks, Nick. I appreciate it. And thanks to all of our distinguished panel, as well as thanks to all of you who were participating and watching and listening to our webinar. if for no other reason than you gave all of us an excuse to get out of our pajamas this morning, as Diana said.
And shave. And shave. It's shave day.
And shave. We're waiting for you to shave, Nick.
Hey, I trimmed.
For those of you who are looking for CLE credit, in the notes you'll see codes 1 and 2, Dr. Fauci. That's Dr. Fauci, F-A-U-C-I. I know there were a lot of questions that we saw in the chat that I apologize, unfortunately, we didn't have time to get to. We will send an email out to everyone who's registered with all of our panelists' contact information. Please feel free to reach out to them, email them, give them a call. They're here and happy to answer your questions and help in any way that they can. Next week, we'll be continuing Bressler's COVID-19 weekly webinar. We'll be taking a deep dive into employment issues that all of your businesses are facing. We hope you'll join us. Again, thank you and stay safe. Everybody have a good afternoon.
Thanks, everybody.